મીનાબેન મોહનભાઈ, વકીલ શ્રી એસબી શર્મા, મોહનભાઈ વજાભાઈ, મોહનભાઈ વજાભાઈ, વકીલ શ્રી જેડ જે સુલેમાની, એમાં અરજદારની સાહેબ લેખિત દલીલ આવેલી છે. અરજદારની આવી ગયેલી સામે. ભરતકુમાર નારણદાસ, વકીલ શ્રી આર એસ મજમુદાર, સહી બાત. શૈલેષજી કુંવરજી, વકીલ શ્રી એસસી પટેલ, એ આવી નથી સાહેબ, હજી નીચેથી આવશે. આ રીતે
મરણ થઈ ગયું 20% નો ઓર્ડર ના થઈ ગયો.
હા,
ચાન્સ મારો તો લઈ આવી.
જામીન હોય તો પછી લઈ. અશ્વિનજી શંકરજી, વકીલ શ્રી એસપી રોહિત, પરેશજી કાંતિજી, વકીલ શ્રી એમ ઠક્કર, એક ને બે નો વોરંટ છે સાહેબ. પરસોત્તમભાઈ મંછારા, તમારું નામ શું? 6 નંબર હાજર. 3-4 નો રિપોર્ટ, 5 એબેટ છે. જામીનદાર 2 નંબરના કર્યું સાહેબ, હાજર નથી. 2 નંબરના જામીનદાર ને કરેલું છે, વગર બજે આવી પોકાર કર્યો, હાજર નથી. જામીનદાર ની ખાલી વોરંટ જ આવીશું બધા. મળી આવે મજૂરી કામે બહાર મળી આવે એવું લખીશ. જામીનદાર નોટિસ કરીએ છે ના આ સાહેબ આટલું એક કાગળ આવીશ, હવે એની આગળનું નથી એ આની સાથે આનું તો નિવેદન છે જ આનું.
હા, એ તો આ તો આવશે નહીં. वो जर्नी था बोल रहा
હા.
तो
12-11-19 પાછળ 26-11 26-11 કહાર લાલો નરેશભાઈ, વકીલ શ્રી એસયુ સૈયદ, અબ્દુલભાઈ ઇબ્રાહીમભાઈ, આમાં સાહેબ 2 અને 3 નો સમન્સ કરેલો. એમાં 2 નંબર કેશાજી મણાજી નો મરણનો દાખલો, પણ એમાં મરણનો દાખલો સાહેબ આમાં 2 ના સમન્સ કરે તો એકનો મરણનો દાખલો આવ્યો, પણ એમને વાઈફ નો મરણનો દાખલો લાગે છે. કેશાજી મલાજી નો નથી. ઉપર નામ કાંતાબેન લખીશ. કોણ હાજર છે? 35-19 માં 2 અને 5 હાજર. બીજા બધા એબસન્ટ. અબ્દુલભાઈ ઇબ્રાહીમભાઈ હાજર. ઓકે. હા, એક જણ હાજર. બેસો બહાર બોલાઈએ. સબીરભાઈ નથુભાઈ, વકીલ શ્રી જે.આર. સુમરા, બહાર બેસો. તમે વકીલ સાહેબ આવે એટલે પછી બોલાઈએ. બધા હાજર છો? બધા હાજર? સારું, બેસો. વકીલ સાહેબ આવે ને એટલે બોલાઈએ તમને. અમરસિંહ કેસરીસિંહ, અમરસિંહ કેસરીસિંહ, બેન સાહેબ વોરંટ ચાલે. આ સિરિયલ નંબર 13 આગળ હતો ને એનો પુરવણી છે. આમાં 4 બાકી છે. સૈયદ ભાઈ સિરિયલ નંબર લખો. સિરિયલ નંબર લખો.
તમને લખો ને પેલી નંબર દઈને વોરંટ આપે ને નંબર દઈને વોરંટ આપતો હોય.
ડીલે નું પૂછે એમાં સર. જામીનદાર છૂટા થયેલા છે. હા, 2 નંબરમાં. હા, બીજા બધા હાજર છે 13-20 માં. વકીલ શ્રી જેસી ઠાકોર. કોને જેસી ઠાકોર હાજર ના તો રિપોર્ટ આપી દો. અમાન સાહેબ પેલામાં 1 જ તારીખ આપીશું કારણ કે પુરવણી પછી તારીખ આપી. પ્રકાશભાઈ નરોત્તમભાઈ, વકીલ શ્રી યુજી કેલા. આમાં સાહેબ આઈવન બોલાયા છે પણ એ બંદોબસ્તમાં છે એટલે વગર બચી આવ્યું છે. સમજ. પંડ્યા સાહેબ 16-21 માં. વકીલ શ્રી યુજી કેલા 16-21. નવરાત્રીના બંદોબસ્તમાં એવું લખ્યું. પૂછો ને વીસી થી 16-21 આરજી ચોત્રી. આરોપી હાજર નથી સાહેબ. જોઈએ. ફારૂકી હયુમુદ્દીન શરીફુદ્દીન, વકીલ શ્રી એનઆર પરમાર. ફતેહ ખાન અબ્દુલ ખાન. અબ્દુલ કયુમ મોહમ્મદભાઈ. દક્ષિણ 16-21. આમાં હશે 16-21. શું નામ આમનું? અબ્દુલ કયુમ 10 નંબર છે. મોહમ્મદ આસિફ મોહમ્મદ હુસૈન. ત્રણેય સાહેબ ફરિયાદી છે આમાં હમણાં બધાને બજી ગયું છે એક જ જણ હાજર છે 212 બોલાવીએ
Yes.
કેતુલ કુમાર કનૈયાલાલ વકીલ શ્રી આર એસ વણકર નીતિન કુમાર ભગવાનભાઈ બીડબ્લ્યુ બજીન આવ્યું છે 8221 માં બીડબ્લ્યુ બજીન આવ્યું છે હાજર નીતિનભાઈ અજય કુમાર સેધાભાઈ વિષ્ણુજી જોગાજી એક હારે નીતિનભાઈ બાર બેસો બોલાવી બેસો અવતારસિંહ જીતસિંહ વકીલ શ્રી એસપી નિમાવત પીએસઆઈ શ્રી એબી ભટ્ટ બધાને બજી નાઈ હશે 19/20 આઈઓ શ્રી એમજી ચૌહાણ પંડ્યા સાહેબ આ ઠક્કર સાહેબ છે આમાં આયા છે કોઈ આઈઓ એમ ચૌધરી પીએસઆઈ શ્રી પીએસઆઈ શ્રી ડીકે ચૌધરી બધાને બજી નાઈ બધાને બજી નાઈ પંડ્યા સાહેબ બેસાડો અમને બાર હા એ જ છે બધું યશકરણ અમરસિંહ
કયું લીધું?
69/22 એમને બજી નાયું પીએસઓ અને એ બી ભટ્ટ બંનેમાં છે 68 ને 69 બંને બજીને જ આવ્યું છે બધામાં હવે 74/23 જિગ્નેશભાઈ નવીનચંદ્ર જ્યોત્સનાબેન કાંતિજી અરવિંદભાઈ અંબાલાલભાઈ અરવિંદભાઈ અને બધેસંગ બાબુજી શું નામ તમારું
કયો?
એમનું નામ શું બધેસિંગ અને અરવિંદભાઈ હાજર સારું 212 બોલાવીએ જ્યોત્સનાબેન હાજર નથી યોગેશ કુમાર ભરતભાઈ વકીલ શ્રી એચ એન પટેલ માફી રિપોર્ટ ચાર્જ ઉપર સર બાર 11 અલ્પેશ કુમાર ભોજાભાઈ વકીલ શ્રી કેજે શ્રીમાળી ડી બાકી છે પંડ્યા સાહેબ એસીબી 4/23 આરોપી હાજર 3/12 અજમલજી વાઘાજી વકીલ શ્રી એલ દેસાઈ હાજર અલ્પેશ કુમાર ચંદુલાલ ચેતન કુમાર બાબુલાલ બંને હાજર
Yes.
બેસો બેસો કાકા બાર બોલાય સતીશ કુમાર રમેશચંદ્ર વકીલ શ્રી જીકે પંચાલ
તમારી
ઇન્વેન્ટરી રિપોર્ટ સાહેબ બાકી છે ને. ઘનશ્યામભાઈ ધુડાભાઈ. પંડ્યા સાહેબ ઇન્વેન્ટરી રિપોર્ટ નું હતું ને આમાં આસોડી આયુન બોલાયા હતા ને ગઈ વખતે પછી હા પછી એમની જોડે મંગાવીશું ને તમે રિપોર્ટ કે શું એમને રિપોર્ટ કરવાનો હતો ને એવું કઈ હતું. હમ? 5 અગિયાર 18 નો છે 5 અગિયાર જીવણજી સરતાનજી ડાયરેક્શન વકીલ શ્રી આર.એસ. વણકર આઈઓ શ્રી પીજે સોલંકી પંડ્યા સાહેબ સમજ કરવાના પીજે સોલંકી સમજ કરવાના હતા. રિપોર્ટ આપે લક્ષ્મણજી કેશાજી કોઈ નથી બોલાયા 3/12 આમને કો 12 બેસવા વકીલ શ્રી એનસી રંગરેજ
के पाटिल बी के पाटिल जीटी तिवारी जीटी तिवारी ने बेचे जीटी तिवारी Madam, for the applicants in serial numbers 8 and 10, Swapnil Prajapati and Evan Agarwal. My lord, this bail has been argued before my lord earlier as well. If my lord recalls my learned friend letter. So I'm not going to dwell too much into the facts, but circumstances have changed since. Earlier criminal miscellaneous application 820 was argued, which came to be rejected by my lord by the order dated 6th September 2024. My lord. What needs to be taken into consideration is, my lord, I have been in custody since 20th of July 2024. More than 65 days have elapsed. And in fact, from the order of my lord's rejection on 6th September 2024, almost a month has passed. From the date of rejection of my lord's order till today, a charge sheet came to be filed under section 173 on 17th-9/2024. My lord. That charge sheet, we have annexed a copy of it. At page number 12, exhibit B. My lord has that. Page number 12, exhibit B. Final thoughts. Next to that, page number 14, my lord will find, I have been named Swapnil Prajapati as accused number 1 on page 14. And on page 15, Hemant Agarwal has been named as an accused. What is pertinent, my lord, might draw your attention is on page 17, 17. Particulars of the witnesses to be examined. 20 witnesses are there, my lord, which have been named as witnesses. And everything that needs, in my humble submission, everything that needs to be recorded in statement has come on record. There is no scope for me to influence any witness. My lord may also see on page 17, serial number 13 and 14. Serial number 13 and 14, my lord, and the eyebrow market research based to capital under section 1111B securities, my lord, and the. So documents pertaining to this company, of which I was a director, are on record. And para 14 is the account detail, where the first informant transferred money. So that account details is also on record. From the account details, it is very easy to see who deposited money, who took out money, who the ultimate beneficiary of those funds. In that sense, everything that needs to be there on record, investigation has been completed. The accused are for more than 75 days in jail, in police custody. And since documents are also on record, there is no scope for me to tamper with any evidence as such, apart from the witness statements. Also, if I may draw my lord's attention to exhibit K at page 128 of this compilation. This is the order of SEBI. This is the order of SEBI, where certain complaints were filed against the company, and SEBI conducted its own investigation for a period of 5 years. My lord. Under section 26 of the SEBI Act itself, any complaint with regards to the securities shall go to the SEBI, the board, and only the board shall have the power to take cognizance in this. So in that respect, anything to do with the company Eyebrow, which was registered as an investment advisor under the SEBI Act, SEBI was empowered to adjudicate those complaints. At the cost of repetition, because this was already brought to my lord's attention, if my lord would just turn to page 160. Issue 8 in between. Whether Eyebrow, the company where I was the director, had violated provisions of PSUPP regulations read in section 12A, A, B, and C of SEBI. Now, since this is already been brought, one of this paragraph, para 65, notes the observation of the board, SEBI board, wherein it categorically says, and I will read, my lord, I'm reading from sixth line from top, fifth line. It has to be noted, my lord, has the fifth line from top. It has to be noted in the preceding paragraphs that in light of Honorable SAT order in the matter of gold research investment advisors and in facts and circumstances of this case, relevant parts of which are similar to the facts of this order, the assured written allegations made against Eyebrow is not established. Consequently, it cannot be held that Eyebrow has violated provisions of PFUTP regulations read with SEBI Act. The charge of fraud under PFUPP regulation in the context of other allegations before by Hydro essentially flows from the allegation of Hydro having fraudulently assured returns. In my view, when the charge of fraud is inconclusive in this context of assured returns allegation, the charge of fraud in context of other defaults would not survive, particularly since there is no specific material to individually support the allegations of fraud vis-a-vis other defaults. In view of that, Hybro cannot be said to have violated regulation 3AB, whatever that may be. My essential contention is that even though the complaints were filed with SEBI, after 5 years of investigation, there is no fraud. The allegation of fraud would have been if there was assured return. Now, my lord, I will draw a parallel. Assured returns is an inducement, is a misrepresentation. If I would have promised the complainant assured returns, that would categorize as an inducement or misrepresentation, which I could not have done. So when SEBI, the body assigned to deal with security cases, says, I have not given any assured returns, the concept of inducement in criminal law will not survive. But that is going into the merits of section 420, which I am not, because I am here for bail. I am not arguing on merits of this. Today, why is bail required? So in this context, my lord, from the time that my lord was of the opinion that the bail should be rejected on 6th of September, my lord, there have been drastic change in circumstances at that point. My lord had based his observation, and if I go to my lord's previous order, on the fact that the accused were absconding. My lord, it is a fact that from 20th of July, I'm in custody of the prosecution, B division. Every investigation that needed to be done has been done, and subsequently on 17th of September, a charge sheet has been filed. My lord had also observed that 449 complaints were filed before SEBI. My lord. As I pointed out, SEBI has given me a clean sheet for the acquisition of assured returns vis-a-vis fraud. When I have not promised anything, if SEBI has said so, then how can there be cheating? In any case, I have been exonerated. I have shown my lord this order of SEBI of 20th of September 2020. My lord had said that there are other accused who are absconding and not being traced. I have categorically said I have no idea who the other accused are, because according to me, the FIR is false and frivolous, and any investigation to that effect can only lead to certain things that are available. My incarceration, my jail time, my remand will not. For 75 days, these accused are still, I cannot be asked them to take. Whatever knowledge I had already provided. And last but not the least, my lord was of the opinion that prima facie case has been made. Now, evidence is before my lord in terms of charge sheet. Everything that needs to be come on record has come on record. The prima facie case is made up or not made up has to be now at this juncture decided on based of the charge sheet, and my lord will frame charges accordingly or discharge it, whatever that may be. But that has to go through the test of trial. Today, why my continued remand is required? That should be the question. And my humble opinion, after everything is on record, my continued incarceration is not required. If my lord which is if I'll just briefly touch upon the case also. If my lord were to read the FIR and everything, it is a known fact that the FIR, the first informant in the FIR was a gentleman called Deepak Bhai Kakran, who himself was a very person who dealt with share markets, had demat accounts, and etc. So he was not an individual who was a layman in that sense. My lord, we have already appraised, my lord, of how the company worked with us. We were not investing. We were in business of what in a layman's language my lord would call is providing tips. That and I would take service fee to provide those tips to you. You come, okay, I have a high risk tip package, like you will like, okay, I will give you 5 tips, you give me money for that 5 tips, you take. That was what in a very layman's language, that was what the companies did. And people had their own individual way of coming to us. There was no inducement. We, in fact, gave them free trials. And I will quickly run through the document that we have provided so that my lord knows what we are submitting to. So in this particular matter, my lord, on 19th of March 2014, and on 9th of October 2014, the first informant took 2 free trials on our website. He got, he submitted the documents, he got, yes, this is a genuine case, and then he confirmed to avail our services. And once you confirm that, yes, you will take my services and you will take tips from me, I call for KYC documents that is mandated under law. Moreover, I also provide a welcome email detailing all my terms and policies. Very quickly, that my lord will see at Annexure D of what I provided at page 22. And since my learned friend has already taken my lord during earlier, I will quickly just so that my lord knows. My lord has that. This is Deepak Bhai's photograph at Annexure C. These are the risk profiling forms. My lord will see at page 23. Name of the client, Deepak Kumar Thakkar. His registered number is such and such. So such documents were provided. A risk assessment was done. And my lord will see at every page at the bottom, he signs it. To say that he's a layman, he usually dealt with securities. You cannot be said that he's a layman. After doing all of his due diligence, my lord will come to page 20 and I'll just, because this will give my lord more documents and more evidence of my innocence than what will the charge sheet give you. That's what my entire. So my lord has at page 20th, risk assessment, suitability assessment has been provided to. Despite your age, income, you with your free consent and agrees to work in high risk profile services, and he signs at the bottom. Very next page, my lord, 28. 28th email dated 23rd December 2015. Apart from the risk study, we also send him a next page, my lord, page number 29. We send him this welcome email. Again, my lord would read. I'm not going to go into all our terms and policies, including the fact that we do not give, we do not invest money on your behalf. We only in the business of providing service, which I informed my lord in terms of tips. My lord has that. Right. Huh? Right. We do not. I'm coming. I'm coming. All of that. It's a part and parcel. If you see on page 31, there are attachments. I'm coming to each attachment. My lord has that. Page 32 is a service agent. My lord has that. service agreement. So this is 22nd December 2015 again, which acknowledges that the first informant has paid 33 lakhs to us. My lord has that at the very beginning. And the services, my lord has that. For payment for services have been included Agri, Bonanza, Bonanza Agri Premium, Bonfire Agri, Crack Future packages. So these are packages where high risk, because he was on his own accord wanting to invest in high risk products, which I pointed my out, and he's taken away all of these services. And under these services, we have provided tips to the first informant. Point number 2, I have paid for above mentioned services. Point 3, since I traded more than one account of mine and my family members, it is practically not possible for me to share all profit details with Waste to Capital, that is the company. I make payment to Waste only after getting good profits and follow up, and out of the aforementioned services, following services have been completed, and I am satisfied with the services received. Also, the charges for these services are fair and reasonable based on my portfolio size and tips provided by Sheth. Fifth, I am totally satisfied and wish to renew my services with Waste to Capital, and thus willing to make further payment, which I am writing this MOU. Right? And then on the next page, it signs it. So at best, my lord, without going too much into it is a case arising out of a contract of services, where the first informant himself has agreed. My lord. Page 30, and we are not shying away from the fact that we have received money. Then on page 40, my lord, see. This is another email dated 23rd December 2015, sent by the company to the first informant. Again, welcoming him after he went into, he availed the services, entered into the service agreement. So every time he entered into a service agreement, my lord, a welcoming email was sent to us. And subsequently, and I'm not going to go too much into detail, my lord, if you just page 43 for a second. My lord, at page 43. This is another email dated December 24, 2015. And we are writing, and my company is writing rather, to the first informant. My lord, I may be permitted to read. Deepak, dear Deepak Kumar Thakkar, greetings from Waste to Capital. On behalf of WTC, we are pleased to welcome you as a Bonanza Agri Premium. This is a package. Kindly find the attached document for payment received and revert back with signed document. As per telephonic conversation held with your concerned executive, you have willingly upgraded your services from basic agri to Bonanza Agri. The amount of 25,000 rupees paid up for your upgradation of services is with your free consent and sound money. So kindly acknowledge this email within 24 hours as a credential for the aforesaid matters. In case of any updated queries, please let us know within 24 hours, else we hereby will consider this email as a final acknowledgement from your side. Weekly research report combo, equity and commodity at rupees 399, valid up to your service tenure. My lord has that. So he agrees. He agrees to a package. We send him an email. We ask him if he has any queries, please come back to us within 24 hours. Yeah. So what I am also trying to put myself here, my lord, is that if you see the second line, kindly find attached a document. Payment received and revert back with signed document. What would happen is, my lord, I will send this email with attachment. He will have to take a printout, sign, scan, and email me back. So it is not that I was brainwashing you. That give me right now, you had ample opportunity. So somebody who deals the share market is an educated person, enters into the contract of services with me on his free will account, makes money, renews it, and at every time has the option to stop it, but does not stop it. And at every instance, this is been done. Every time that he wishes to go about. So this is what happened. And then one fine day, I believe he realizes that there have been some complaints filed with us. And then he approaches them. This is the circumstances in which everything is on record, my lord. The charge sheet has been filed. The case has been vastly and very elaborately explained to my lord by my learned friend on the last occasion. My lord would recall that. The order of 6 that my lord rejected the previous circumstances, as I said, my lord has changed. 75 days I have been in recovery. If there is anything else that is required from my end, they should have come to me. They have not come to me, charged. My lord, I may be. That's all. And thank you, sir. And they have, apart from 420, I've told my lord, there was, Heavy has said, there is no fraudulent assured returns. So there cannot be any kind of misrepresentation or coercion. 114 is abetting. The other section is 66D of ITR. My lord, I am not impersonated. I'm still saying, I was a director of this company called Hydro. We were registered with SEBI under investment advisory regulations. It was our job to provide you services in terms of tips. Because I was registered as one and I would take money. So 66 also is not applicable in this. And hence, not going into too much, my custody is not required, and whatever terms and conditions my lord would impose, I'll be very obligated to abide by. Obliged.
Yeah, my lord, for the submission. Please, would appreciate that as my lord has already pointed out. My lord has rejected the earlier application because at the stage when the investigation was pending, primarily on 3 counts. One is that there was the prima facie case. Second was that the investigation is ongoing. And third method was that there appears to be some kind of criminal involvement as well organization. She would only appreciate 3 points. My learned friend has already pointed out the order of the SEBI. She would appreciate the proceedings before SEBI are civil. It is conducted after a detailed investigation into the entire affairs of the company. But she would appreciate 2 aspects. One, so far as this matter is concerned, it is allegation of the present complainant vis-a-vis the transaction that he alleges to have happened with the company, as against what has happened with the investigation conducted by SEBI. They conducted the investigation into the entire affairs. Today, why am I being arraigned as an accused in the present FIR? I am only being arraigned as an accused in the present FIR on 2 counts. One is that I served as a director at some point of time in the company when the alleged offence had taken place. Yeah. When the alleged offence had taken place. But there is a specific government in the FIR wherein he says that I was doing business, I was already into the share market. While I was into the share market, I receive a call from this company from time to time. I avail their services for investment advisory tips. And when I realize that I am not making profits, I go to Indore to their office and I meet the officials of the company. And in that meeting, one person, Mr. Hemant Agrawal, who happens to be a director, he was present and he says that the specific allegation as against Hemant Agrawal says that, okay, if you are not happy, what we will do is we will try and trade with you and we'll continue your services if you are not able to make profit of 70,000 rupees per month. That is the First allegation, that what is the role that is attributed as per the FIR to Hemant Agarwal. That is one. Second, that when they say that that meeting of settlement was not fruitful, after few days, Swapnil Prajapati calls and says, okay, fine, if you're still not happy with our services, you paid us X amount, we will refund you 10 lakhs. That's the allegation. Lordship is aware, and in a case under 420, there has to be inducement at the inception of the transaction. It is not the case of the complainant had somebody induced him with some profit motive. I would have understood that I am being arraigned as an accused only for being a director, provided I am running a con shop. If I was running that entire company as a fraudulent business, Lordships would have seen matters after matters. There have been telecall centers where they call up senior citizens and they say there is a fraud in your tax account, you please pay 2,000 rupees. That entire business is fraudulent. In such circumstances, the investigating agency would make the shareholders, the directors, and all office bearers as party accused. But that is not the case here. I am not running a con shop. I am not running a fraudulent business. I am running a genuine business. Some transactions, there is a civil nature of dispute, which is given a twist of a criminal nature. But you would also appreciate the order that my relative had pointed out. Only to explain the definition of fraud, because fraud under the PFUTP regulations has a wider ambit. For a cheating, for an offense under cheating under 420, the ambit is that there has to be an inducement at the inception with a mens rea. Under PFUTP, there is no condition of mens rea. There is no condition of being deceitful or not, but you could only peruse. But you would please, if you may refer to page 158. Is the definition of prohibition of certain dealings in securities. That is regulation 3. Then also would turn to page 139. At the bottom, page 130, bottom 130. Regulation 4. Without prejudice to the provisions of regulation 3, no person shall indulge in a manipulative, fraudulent, or an unfair trade practice in securities market. Explanation: for the removal of doubt, it is clarified that any act of diversion, mutualization, or siphoning of assets or earnings of a company whose securities are listed, or any concealment of such act or any device, scheme, or artifice to manipulate the books of accounts or financial statement of such a company that would directly or indirectly manipulate the price of securities of that company shall always be deemed to have been considered as a manipulative, fraudulent, and an unfair trade practice in the securities market. Dealing in securities shall be deemed to be manipulative, fraudulent, or an unfair trade practice if it involves any of the following: disseminating information or advice through any media, whether physical or digital, which the disseminator knows to be false or misleading in a reckless or a careless manner, and which is designed to or likely to influence the decision of investors dealing in securities. Lord, you would please appreciate, even if I am acting recklessly, without any inducement, without any intention to cheat or defraud, even my mistake, like a reckless mistake, is also cognizable under PFUTP. Now, I am being given clean sheet under that. And second aspect, Lordship would appreciate, Lordship had taken cognizance of the fact that there are approximately 449 complaints pending with the same. Lordship would please appreciate the way this FIR is registered against me. Similarly, various complaints were registered on the source platform. the nature of the scores platform would appreciate. It is not necessary that each complaint is pertaining to some kind of cheating. The nature of the sports platform is that if there is any grievance, it is like a customer relationship platform, which every investment advisory is required to have under the IA regulations as its own internal mechanism. If any grievance is there of a particular client, which is not resolved by the company, that particular client has an option to file that grievance before scores on the scores platform, wherein then there is the exchange between the company's SEBI officials and the complaint. But those 449 complaints, out of which 200 complaints are unique complaints. So the remaining 259 complaints are repeat complaints. And out of those 200 complaints, my thoughts, majority of the complaints are lodged after SEBI had issued a cease and desist notice, a interim order on me on 23rd of May 2019. Lordship would appreciate what has happened. There were certain complaints on the sports platform which said that no, I am not making profits, I am not happy with the services. Based upon that, SEBI conducted a preliminary investigation. Based upon that investigation, SEBI back in the day in 2019 thought it fit that I am not running my business in an appropriate manner, and they issued me an interim order on 23rd May 2019. In that order, they say you need to shut your business from today. So on 23rd May 2019, when the order was served on me, I had to shut my shop, my accounts were frozen. Now, I filed a triggered battle with SEBI for another 5 years, so far as long as 23rd September 2023. On 20th September 2023, I am being given a clean sheet so far as the fraud allegation is concerned. So far as the violation of any other IA regulations are concerned, that they have held that okay, there are certain violations that a particular, but what is the nature of those violations? It is maybe you've not done the KYC in proper format, risk profiling, you should have asked some other question, you've not done that. That is the nature of the violations. And as against that, a penalty of 15 lakhs is imposed on me. And though academically we have challenged that order because we don't want those allegations to stand against us. That matter is still pending before the Securities Appellate Tribunal. But you would appreciate two aspects. The only pendency of any complaints or lodgement of any complaints on scores need not be considered at this stage or at any stage, because that is the grievance redressal platform. So those complaints does not necessarily mean that I have cheated 500. Those complaints did not necessarily mean that I have cheated 500. And majority of, because once my business was stopped, naturally any client whom I had enrolled few months back would have a problem that because he has paid me X amount and I'm unable to give him service. So that is also one of the factors which this honorable court must consider. Last but not least, Doctor would only appreciate that as my learned friend has already pointed out, the investigation is complete. The charge sheet would stand the test of the trial. The only issue where the original first informant, the original complainant is saying that the company had assured him some profit and he has not made any profits. There is a civil finding in my favor. That judicial finding, which is the SEBI's order, must be taken into consideration that when I am being given a clean sheet in a civil trial, where the degree of proof that is required is 3 quarters of probabilities. In a criminal trial, where the degree of proof that will be required will be the proof beyond reasonable doubt. And in such circumstances, if tomorrow I stand the test of trial and if I am acquitted, the continued incarceration would only amount to my infringement of my fundamental rights. In view of that, I rest my case and I'm obliged for a patient. Most obliged. I'm obliged. ये मूवी में कार्य करते हैं। अब 15 दिन लगे ठीक है।